talk about real estate cancellations, something that we've been seeing a lot of, and we'll get into it just in a little bit. Some of the other issues surrounding coronavirus, because people are loving to, of course, now mention and utilize coronavirus for all sorts of things. So what's happening? So normally we would be able to sell a house, we'd have a happy family, agents would be happy, everyone would be good. Now things are a little bit different. We've got our friend Mr. Coronavirus here. It's causing some problems with transactions, causing some anger when it comes to certainly deposit issues, as we'll get into. So let's talk about it. So we're going to get into a bunch of this stuff in our next 2.5 hours that we have here this morning. No, just kidding. We'll try to do this in about 30 minutes. Can I cancel? We're going to go over some of the existing law on cancellation and contracts. What is force majeure? We're going to talk about that. It's got a lot of different names that are being floated about. And there is a civil code here in California, 1511. So we're going to talk about that too. And then, what if the person cancels anyway, or withholds the deposit anyway, or does something like that? So we're going to talk about, what would be the next steps if people can't work it out, and then give you some thoughts. As usual, we have our nice little disclosure. We obviously can't cover everything in the next 30 minutes, but hopefully going to give you a really good idea of sort of what's going on and how these cancellations and force majeure kind of terminology is going to work. So about me, for those of you that are new, or those of you that maybe don't remember, I am a real estate attorney by background. I used to have an office, kind of looked just like this, actually was in trials. This wasn't quite that old, but I definitely did lose a little bit of hair throughout the way. Got to, experience a lot of this fun litigation, a lot of this kind of drama on the back end of real estate, but ultimately really didn't like it. Got a little bit stressed out and decided one day, hey, I have an idea. I would much rather be on the front end of real estate. And so that's what I did. Got involved, kind of started my own company with Lucas Real Estate, got involved with the Newport Beach Association of Realtors, the California Association of Realtors, became one of the first mediators actually on the California Association of Realtors panel. They have a panel, as you know, in the contract, kind of force you to go through mediation. So some great mediators on there, including myself. And then obviously a couple years after that, dragged my wife into the business. Courtney, some of you know, we're both here at Villa now. And today is actually our 8-year wedding anniversary. So I have to give a special shout out to Courtney and thank her. It was basically about 3 or 4 months after we got married that in the middle of the night one day I told her, hey, I want to quit my well-paying secure job and start my own business. So thank you, Courtney, for working with me on that. And then about the past couple of years, I think almost 2.5, almost 3 years now, we've been associated with Villa Real Estate, and obviously very happy here. So, okay, what is going on with coronavirus? Obviously, we know we've got these stay-at-home orders. We've got the governors, we've got county officials, we've got local people shutting things down, signing away, closing everything down. Yes, we are an essential service. We can still go about our business, but as we know, the state is closed, and that's going to be an important distinction that we're going to get into. We've got the security guard here telling us, sorry, Wally World is closed, everything is closed, but yet we still have pickup. We can still go get some food. We could still go get a takeout. You could still go get alcohol. You could still go buy marijuana. Things are still open. This is actually a photo from Huntington Beach this Saturday. As we all know, Newport Beach and Huntington Beach got themselves in a little bit of publicity because it was quite the crowded beach. So these are important distinctions here because this is not wartime. This is not necessarily people dying in the streets and being carted out. And there were much more graphic images if you look back at the original plague and things like that of what it looked like. We don't have that right now, which is going to be important when we start getting into this. But yet we have people that are obviously wanting to put the brakes on things, call a little bit of a timeout, or just outright cancel a transaction because of this. So what happens then? Well, obviously people are either going to be fighting over money or they're going to be fighting over the house. In the case, maybe the seller is the one who's canceling. We're seeing that as well. So there's going to be a dispute. As we all know, these real estate cases can get a little bit dramatic. It's a my home is my castle type of issue is going on. And then we have ego and we have money. If you've been in my sliding scale or my presentations before, you've seen this sliding scale where basically the less ego and the less money we have involved, the less risk of a lawsuit, but the more ego and the more money we have involved, the more likely we are to have a problem, in my experience. Here in our lovely coastal areas, we have very nice properties. We have people with means, and therefore I think, frankly, it's a little more likely to see some disputes in our areas than you might in other areas. And not to say that other properties aren't worth a lot of money. They could be investments. They could be near and dear to people's hearts. But let's be honest, to go through the legal process, people often hire attorneys. That costs money, and it's definitely more common in some of our bigger disputes, or at least they get nastier. Which means ultimately you're going to go to court if you can't work it out or can't figure it out yourselves. And then our friends, the eager attorneys, are going to come into play, who are going to be more than happy to take a nice big retainer and litigate your dispute as long as you would like at $450 an hour. So what's happening in these cases? Well, we've got a nervous buyer or seller is calling you, the super agent, and saying, hey, I need to cancel, or hey, I need a delay, or whatever the issue is that we'll get into in a little bit. And they're going to look to you for guidance. So what do you need to do? Well, first of all, depending on the dispute, you probably need to call your broker. You probably need to talk to someone. You may need to tell your buyer or seller that they may need to seek legal advice. Well, we're going to talk about the law on cancellations, and certainly some of this is going to come up in your discussions with your buyers or sellers. Be careful at the same time not to be practicing law. So you obviously have to, let them know, hey, you should look into this, because if they're trying to cancel a contract, and especially if they start getting lawyer letters, you're going to need to take that seriously. But at the same time, it's important for us all to know. So that's what we're going to talk about. So what's the most important thing? Well, you got to read your contract. There is the law in California that we're going to talk about, but a lot of this is really dictated by the contracts. And specifically, the RPA that we all use, probably 99% of our transactions, it has some very specific timeframes as to due diligence, investigations, and all those things that we're all very familiar with. And we're going to talk about that a little bit. So you could have a loan appraisal, you could have a loan, you could have an appraisal. Maybe they have to actually sell their property. There's all sorts of disclosures. We've got the TDS, the SPQ, the ESD, title, NHD tax. So, buyer investigations, they're going to do a home inspection. Maybe they're going to do a pool inspection. Maybe they're going to do a roof inspection. We all know how this goes. And we have a nice little timeline of the process. So in theory, we hopefully get an acceptance. We're happy about that. We get the EMD. We're very happy about that. But then there's this contingency time frame that everyone has to work in, and then the closing. So once we get to the EMD, that's great. But then, during the contingencies, everyone's a little bit inherently nervous, right? They're going to do an inspection. Are they going to ask for repairs? What's going to happen? So it's always a little bit of a nerve-wracking time, no matter what, even well before coronavirus. Once they remove the contingencies, everyone's happy, right? It's a party, because typically once someone removes the contingencies, then hopefully they're going to close. Now, we all know that's not the case as well, because things can certainly happen in that time frame. But obviously, once someone removes the contingencies, that's a huge milestone that people are generally very happy about. Conversely, if the deal gets canceled, obviously people are going to be sad about that. Buyers, sellers are probably a little upset. And then you're sort of back to the drawing board, square one. You're going to take the property off the market, or you're going to relist the property, or whatever the seller's going to do. So let's talk about some of the two biggest issues that are going to come up. And I promise we're going to get to the force majeure very quickly. These are very difficult concepts in the RPA, and people constantly ask me, where does the RPA say I get my deposit back? Where does the RPA say I get to keep the buyer's deposit? Well, if you've gone through the RPA, you will know that it doesn't exactly say that. You're kind of looking in a vast landscape of, what is it now, 10 pages, that doesn't really, probably as cleanly as people would like, address what happens to the deposits. But we're going to briefly kind of break down what that is. And I think it's relatively simple, but it gets people in trouble. And then especially when we get into this coronavirus issue. So if the seller cancels, this is clear. This says it at two different places, RPA paragraph 14D. So if you're reading along at home, 14D. If you can't see all of this, by the way, don't worry about it. I'm kind of just talking, or you can watch it back in slow motion, but I'll try to highlight what the important things are. So the RPA paragraph 14D, it makes very, very clear that if the seller cancels, then the seller shall, not should, not could, not may, seller shall authorize the return of the buyer's deposit. So it is very clear that if the seller cancels, the buyer gets their deposit back. Very clear. What happens when the buyer cancels? So if the buyer cancels before their contingency removal, there really isn't a magical section in the contract that says you get your deposit back. But if you read it carefully, that's the conclusion. Paragraph 14B3 says that basically the buyer has X days, and we're typically what, at the 17-day window. Some people shorten that, some people make it longer, so that's why it's got a blank in there. But the buyer's going to have X number of days to do one of two things. They're either going to remove their contingencies, or they're going to deliver a cancellation, and it's built right into the contract. So reading that, coming up with what we call like a plain reading of the contract, makes clear that the buyer has these contingencies. They have X days to cancel. And what that means is they get to cancel the deal, and then the deal is done. So logically, they get their deposit back because it's as if there was no deal to begin with, right? You're canceling the deal. So that's kind of how this works. I wish there was a provision that said a little more clearly, buyer gets his or her deposit back, but this is sort of how it's read and how it's interpreted. So one of my biggest tips of the day, long before coronavirus, that gets people in trouble is why they're canceling. My tip of the day, and I think I'm gonna have two of them for you, but this is one of the biggest ones. No reason is required when you are canceling your sales transaction on the buyer end. I would encourage you probably not to give a reason. And the reason for that is because reasons foster disputes. It was kind of a long known issue in landlord-tenant law. Now we have rent control, so you can't always do this if you're subject to rent control, but don't give a reason. You know, if you're going to evict your tenant or you're going to send a 60-day notice under non-rent control situations, you don't give a reason for that. Same thing, I hate to say it, but when it comes to terminating employees, there's a very old adage that you do not give a reason. Same thing here. Think about giving a reason when you cancel, because if you give a reason, they're just going to argue over it. So what I see very frequently is people cancel saying they couldn't get the loan. Well, if you're the seller or you're the seller's agent and a buyer tells you they couldn't get a loan, what are you going to do? The human nature is going to say, call my guy. I've got referrals for you. I've got other lenders you can try. You know, the seller and the seller's agent is going to instinctively try to work it out. So a lot of times, really, the smartest way I see deals canceled is when people just write in, either literally leave it blank, or you check that box and just say pursuant to due diligence or pursuant to paragraph 14. You just kind of give some big catch-all. But when people say, hey, I want to cancel over, because I can't get a loan, or I want to cancel because the roof's leaking, inherently the seller's going to try to make a deal. And maybe that's what you want, but that's more of a request for repair then versus the cancellation. So bottom line, be careful on the cancellations, because I've actually seen people right now in the cancellations, coronavirus. And that's going to get you in a lot of trouble, as we'll talk about in a second. So if you're going to cancel over coronavirus, for the love of God, don't say I'm canceling over coronavirus. You've got to be more creative, that we'll talk about. As we all know, as I just put on that slide, there's a million reasons why a buyer can cancel prior to contingency removal. So you don't need to say coronavirus. You can use any one of the million other things. So, okay, enough about that. What if the buyer cancels after the contingencies are removed? This is one that's coming up. I've seen a couple disputes on this, where either the buyer completely removed their contingencies, or perhaps there were no contingencies to begin with. Maybe it was an all cash, contingencies waived type deal. Well, that's, problematic. If you look at paragraph 14F of the purchase agreement, it basically says this, and don't worry if you can't read this. It basically says, hey, when you remove contingencies, or effectively if you submit an offer without contingencies, you're done. It is a done deal. The buyer shall conclusively be deemed to basically elect to proceed with the transaction. So by removing those contingencies, you're saying, hey, I'm good to go. So we now have a binding contract. So again, does it say I get the deposit back? Sort of. We have a liquidated damages provision, which, by the way, only works if both parties check the box, which they usually do. And if you read that liquidated damages provision, you'll see that basically then, in theory, if the buyer doesn't perform at that point in time, the seller could keep the earnest money deposit up to 3% of the purchase price. Now, liquidated damages in itself is problematic, and you could do a whole other topic on that. It's not always that black and white. So even if you're the seller and you have this slam dunk cancellation, just because you've signed the liquidated damage provision still doesn't even mean you're going to get the 3%, but it's kind of starting that process. If you didn't initial the liquidated damages provision, then you're just in an old-fashioned lawsuit over damages, and you would have to actually prove damages. So if you as a seller hypothetically sell your property a month later for the exact same price, well, you weren't damaged at all. You know, maybe you can argue you had a month worth of carry costs or something, but really there's no damage. Whereas let's say you as the seller have to sell your house 2 or 3 months later for $100,000 less because the market's deteriorated or you lost other buyers or whatever. Well, in theory now you're going to argue over that 100 grand, but that's a hard lawsuit to make as far as the diminution of value and all those things. So that's why the liquidated damages clause exists, is to hopefully avoid that argument. But that's it. So you know, I thought that was very important to kind of understand, because that's how it worked always before coronavirus, and now people are trying to throw coronavirus into the mix. So we'll talk about that. One of my favorite misconceptions about the deposit disputes, when you can get your deposit back and things like that, is this issue of the contingency. So this is what I mean. So let's say you have a 17-day contingency, or let's say you wrote in, you know, the buyer to remove every contingency 10 days, whatever it is, doesn't matter. Once you get to this date, so let's say it's day 11, or it's day 18, it's day 25, let's say it's day 500, it doesn't matter. There are some sellers out there or people that have a misunderstanding that once you reach that line, that magical line, that the contingencies remove themselves. And it does work that way in other states. I had a client buy something in Utah, for example, and it is that way, where, you know, at day 10, if that's how long you have for contingencies, on day 11, your contingencies are removed for you. We don't do it that way. We're in California, we're a consumer-friendly state. So our contract and the law is written to be very clear on this issue. So let's say the buyer goes way past this deadline, you know, again, let's say it's, you know, days, weeks later. There is a paragraph 14b4, that makes abundantly clear that even after the end of the time period, buyer retains the right to remove their contingencies or cancel. So I love when I see legal disputes, people come in and say, oh, it was, you know, day 30, therefore they removed their contingencies, therefore we get to keep their deposit. And that is just dead wrong. The buyer has to affirmatively remove their contingencies before there is any attempt or any potential for that deposit to be at issue. So it's very important. What happens if the buyer doesn't remove their contingencies? This is what happens. You're caught in this endless circle. So if the buyer doesn't remove their contingencies, the seller can send a notice to perform, and then the seller can cancel. But remember what I told you just a minute ago, if the seller cancels, the buyer gets their deposit back. And if the buyer cancels before removing contingencies, the buyer gets the deposit back. So again, if your buyer hasn't removed their contingencies and you've got an annoyed seller, I'm sorry, but there's no way that you're keeping that deposit unless the buyer actually removed the contingencies. You're stuck. You're stuck in a circle where the buyer is going to get their deposit back. So this is super common issue. I wanted people to understand this before we get into now the new creative excuses. So again, because we are in California, we do have our nice consumer-friendly state. That's the way our laws work. It's very clear. So 25 minutes later, we've got it. On to our feature presentation. Force majeure, Civil Code 1511, act of God, unforeseen circumstances, impossibility of performance, commercial frustration, frustration of purpose. These are just the ones that I could think of off the top of my head. I'm sure creative lawyers are going to come up with other ways to phrase it. It's all a doctrine that we can call force majeure. There are some differences to it. It comes about from a long series of case law and something that we got even back from England. And people ask, several people have asked me, where do I find this in the RPA? Well, you don't. It's not in the RPA. Now, they've come out with this Coronavirus Addendum, and I'm sure in the pending months or years, we'll probably have it in the RPA, but it's not. And the reason I tell people it's not in the RPA, well, it doesn't really have to be. Force majeure and these things that we're going to talk about, these are concepts in the law. They're not contractual. So you don't have to have it in your contract. Kind of like in the same way your contract doesn't say, hey, we agree not to, you know, have a duel to the death to see who gets to keep the house at the end of the day. You know, you don't have to have something in a contract that's already the law. But that being said, I'm sure people are going to put it in eventually. Now, we do see it in very high-end contracts or commercial leases because some people specifically exclude it. So if you have a lease with, say, for example, the Irvine Company, i.e. Villa, I haven't seen your lease, but the lease probably has a provision that says, hey, force majeure, act of God, civil disobedience are not excuses to not pay the rent. So you can actually affirmatively carve some of this stuff out. But as far as putting it in there, you don't need to, it's already the law. So, and then we have these coronavirus addendums that we talked about that upend things. But so let's talk about force majeure. What the heck is force majeure? It's an excuse, right? It's saying, hey, things outside of my control happened, therefore I should be let out of the contract. That's sort of the easy way to say it. We've got lots of fun case law that talks about, I love this word, an insuperable interference occurring without the party's intervention as could not have been prevented by the exercise of prudence, diligence, and care. And this is going to be important because it's really going to be a two-step process here for anyone trying to claim a force majeure defense. First of all, you have to prove that it stopped you, and then you really have to prove that you tried to do something else. So for a lot of reasons, maybe spoiler alert, you can't just throw up your hands and say coronavirus. There's going to be a lot more to it than that. So Civil Code 1511, for those of you that want to take a look, again, don't worry if you can't look at this, you can go look at it later. Civil Code 1511, it basically has three reasons that are built into California law as to why you could, in theory, get out of a contract. The first reason is by operation of law. So that's going to come up. If the government closes your business, people are certainly going to argue, hey, by operation of law, I cannot proceed. So sounds good, but we'll dig deeper. Number two, when prevention is delayed by an irresistible superhuman cause or by the act of public enemies of this state. Irresistible superhuman cause, I think, is California's way of saying act of God, because we don't use the word God in California, so this is how we say it. But that's what this is intending to mean. So enemy of the state, so that's war, right? War, things like that are excused. And then the third one, which isn't applicable, but basically if the debtor tells you not to pay by the creditor, then you don't have to pay if they told you to pay. Don't worry about that. Numbers 1 and 2 of Civil Code 1511 are what people are going to be arguing about for the next several years. So we're going to go over a couple examples. In California law, basically, as I said, it's got to be sufficient, reasonable efforts to avoid the consequence. So again, you can't just say coronavirus, you've got to try to do something about it. Got some great examples we're going to go through real quick. So this is a 1960 California Court of Appeal case, Butler versus Nepal. And in this particular case, a drilling company couldn't get supplies because there was a strike, right? So a strike, force majeure, it's outside of my control. I can't control it, blah, blah, blah. But the court ultimately said, no, sorry, that's not good enough. You needed to look at other supply chains. Yeah, supplier A had a strike, but why didn't you go to supplier B, C, or D? Even if it was more expensive, that's what the court said that they should have done. This is a great analogy, for example, people that say, I couldn't get a loan. Well, the law right here so far, we've already talked about, is dictating, hey, you better try to get a different loan at the very least. So this is a case that's telling us, look, you got to try. You got to try to figure something else out. You got to go to plan B. Lloyd versus Murphy, another California case, California Supreme Court, actually had a very similar outcome. So there was a new car dealership amongst World War II. And if you don't know, basically in World War II, the government said, hey, stop making cars. You need to build tanks and airplanes and bombs and things like that. So nothing was rolling off the Ford assembly line except tanks. And basically this car dealership said, hey, I can't sell cars because I can't get cars. Again, Supreme Court said, no, sorry. You can still run your business. You can still get cars. Maybe you're a used car dealership now. So again, this is kind of a harsh outcome. Even though the government basically said, we're not making cars anymore, the car dealership couldn't get out of its lease. I think that's, again, not looking too good for people that are going to argue force majeure. We've got one more one, very similar outcome. Mitchell versus Cezanne Tires, 1944 Supreme Court case. Very similar fact pattern. We had a World War II tire shortage. Again, so the tire company says, hey, I can't, make my business because of this. Well, something very unique in that one, the court also took into the fact that while they were negotiating the lease, it was well known that the US was considering getting into the war. And so that was another reason that they used to deny this force majeure claim. So this is a great example for people that have gotten into their contracts in the last couple weeks. This has been going on long enough that there probably, to be honest, aren't a lot of contracts left, for people that entered into contract in December or, before this really came about. So certainly to the extent that someone got into their contract in the last couple weeks, that's going to be a real hard argument because clearly you knew. It's getting into sort of like an assumption of the risk type argument, like as if you go skydiving. So basically, force majeure not looking too good for people that are trying to use that as an excuse. Now, lawyers are going to have a field day with this because, you know, it depends. Obviously, all of these cases are going to be fact specific. You could see someone coming up with a very good argument, you know, that they couldn't perform, but I think it's going to be pretty darn tough. So let's talk about that real quick. So how does this come up? So I'm kind of hypothesizing 4 ways that this is really coming up. We've got a cancellation, obviously a buyer or a seller trying to get out of the deal outright. We've got a demand for additional time. This is going to get a little more tricky. Let's say someone, you know, just wants some more time. We've got an attempt to renegotiate. So we'll talk about that, renegotiate. And then I'm going to see this as a defense. So this probably won't be a big deal to us right now, but as, for example, commercial tenants, as some very high dollar disputes start coming up, tenants and other people are going to have a defense saying, hey, I couldn't pay because of X, Y, and Z. So those are kind of the 4 ways that I see it coming up. Let's talk about these briefly. So as far as renegotiation, let's talk about that one first, because that to me is very easy. Renegotiation is just a jerk way of going about option number 1, right? Canceling. So if you're legitimately saying coronavirus is affecting the transaction where I need to cancel, I don't see how in good faith someone can renegotiate. So if you're saying, yeah, I can still go forward with the deal, but I want 100 grand off, well, you've just shot yourself in the foot, because then you don't have the inability to perform because you can perform. You just want a discount. So in my mind, renegotiation is going nowhere legally. Now, practically, it's clearly going to work because they have you over a barrel. And if someone says, hey, I want 100 grand off, you're either going to sell the house or you're going to, you know, go back to square one. So practically it might work, but legally, that's going to not work out well for people trying to renegotiate. So let's talk about a demand for additional time. This is where I think people are going to get really be able to kind of utilize this, and especially if you make it a request for additional time. So, you know, if you, Mr. Buyer or seller, legitimately are getting some information from your bank, says, hey, we're going to need an extra week or 2 to process this loan or whatnot, I think that is definitely going to sort of create a dialogue that's going to have to be had with the seller. And I think, you know, all things being equal, if a buyer says, hey, I need a couple more weeks, assuming they have, you know, still contingencies, hey, I need a couple more weeks, I think it's going to be very reasonable to have to grant that. So I think this is kind of the issue that I see people getting maybe in trouble with the most, is a seller saying, you know, heck no, I'm not giving you an extra week. And the buyer saying, well, you know, I want to close, I just can't. And that's going to, you know, cause a little bit of a problem. Now, that's going to be a different story if they've already removed their contingencies, or if it was an all cash transaction or something like that, you know, then maybe you can call BS, or it clearly just is an excuse. But if they're making it sound really legitimate, like they just need an extra week or 2, I think you're going to be hard pressed to deny that. So this is really kind of one of the big issues. So tip of the day in dealing with this, we'll talk about cancellations in a second, is I'm just kind of telling everyone, you know, coronavirus, yeah, it's a thing, but what has it really done? So I'd like to know, what would you do before coronavirus? Or the simple acronym WWYDBCV. So if we all just kind of think about this as we're going about our transaction, I think that would be very helpful. So for example, you know, let's say before coronavirus, a buyer has a loan and everything's looking good, and they come to you and they just say, hey, I need another week or 2 to process this loan. Well, you know, some people might not be interested in that to begin with, but I think most people would try to work it out, would try to make that accommodation. So I think the courts, ultimately, when this hits the fan, if people are in court years from now, is not going to look favorably on people that weren't necessarily being kind. I think common sense will kind of come into play on a lot of that. But as far as the cancellations are concerned, you know, that's when you're getting really dicey. This was the best graphic I could get for being dicey. But, you know, look, it is clear that you have to not be able to perform, and you have to have exhausted all other avenues before you can get there. So I'm hard pressed to think of a hypothetical situation where someone is going to be able to get out of a contract. I'm sure it's going to exist. I'm sure someone's going to have a great story about, you know, their money got tied up.
You can tie it right over there and do these.
Oh, someone else came in. story about their money being tied up or something like that. So I'm sure it's going to happen. But from what I've read and seen, this is a long shot argument at best. So, what if after all that knowledge, the person just cancels anyway, or they ultimately, just give us the finger? Wouldn't be one of my presentations without someone giving us the finger. Well, you're kind of stuck back to where you would have been. People are going to fight over the money. They're going to fight over the house. You have to go through mediation. We've done whole other presentations on that. In the contract, you have to go through mediation before you can just file a lawsuit. Ultimately, you're going to end up in arbitration or court. You're going to have to hire these guys, our ready, willing, and able attorneys, and it's going to be a problem. It's going to be a problem more so now because courts are closed. This, unfortunately, is just going to obviously add some leverage to people that are getting, people that are on the short end of the stick. If you have an arbitration, you can still proceed with an arbitration. That's not going to slow it down. They're doing virtual arbitrations, just like we're doing virtual mediations. But if you're trying to go to regular court, good luck. Yeah, you can technically file a lawsuit. It's only evictions that are kind of banned right now, but you can file it. You're not going to get it back for weeks, and everything is stayed. Everything is stayed. So even if you could file a lawsuit, you're not going to get a court hearing. You're not going to get a trial. They're not even calendaring things, period. Once they do reopen the courts, there's going to be obviously all the criminal cases are going to get first priority. Things that were already backlogged are going to get priority. Evictions are then going to have to get priority. So regular old civil lawsuits are going to be at the back of the line. So if you thought it took a year or two before coronavirus to get your day in court, it is not going to get easier. So that's unfortunate. And then think of, to get to court, we go through all these hassles, we do depositions, we go to court, we have a trial. Some of these are legal issues that a judge may decide, but some of these are things that you have to go to a jury. You're rolling the dice on the potential outcome. Because one of the important things to keep in mind here is that, your judge may do one thing, this judge may do another thing, this judge may do something else than this judge. And before you know it, we have, 30, 40, or 100 different outcomes of the same ruling. That's exactly the way our legal system works. So right here at the state court level, this is us, civil court, we could ultimately get hundreds of conflicting opinions or hundreds of different outcomes. It's not until people actually take it up to a court of appeal, which is where you're before a judge, judges, no jury. So that's a court of appeal. And then people ultimately are going to take it up to the Supreme Court. Years. We're talking years. So it is going to be years, plural, until we have real case law in the state of California that gives examples of coronavirus being an excuse to get out of contracts. And it's not just real estate. Believe me, lots of industries are going to be using this excuse. So it won't just be us, but it will be interesting to see how come some come into play in real estate. So that's it. That's sort of my conclusion. Try to avoid court if you can. Try to avoid hiring the attorneys if you can. It's always a good idea to try to work it out. Try to think, what would you do before coronavirus? Try to insert a word, someone lost their job, someone's sick, someone's ill. If that would have mattered before coronavirus, it probably matters now. But again, just saying coronavirus, in my opinion, is going nowhere. So that's it. That's all I have for you.